Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3029, United States of America versus Ngozi appellant. Ms. Stern for the appellant, Mr. Sinha for the appellee.
Good morning, counsel. Ms. Stern, please proceed when you're ready.
Thank you, Your Honor. Good morning, and may it please the court. Ilana Stern on behalf of the appellant Ngozi Poll. The court should reverse the district court's denial of Mr. Poll's motion for a new trial on the basis of ineffective assistance of counsel. Because the government effectively concedes constitutionally deficient performance by counsel in this case, I would like to focus my comments today on the prejudice prong of the Strickland analysis. Specifically, I would like to address two issues. First, trial counsel's failure to object to Mr. Molganicki's testimony that was admitted in violation of Federal Rule of Evidence 408. And second, trial counsel's failure to object to the government's use of Mr. Poll's oath of office in its closing arguments. Both of these errors went to the critical issue in this case, Mr. Poll's state of mind. Mr. Molganicki's testimony went directly to this critical question, and trial counsel's failure to object was prejudicial for two reasons. First, under this court's opinion in Davis, this testimony is precluded. Under Davis, Federal Rule 408 violative testimony admitted in error is grounds for vacatur and remand. In Davis, strikingly similar, though arguably less damaging testimony regarding an offer to repay a contested sum was admitted over objection. And there, the government, as in Mr. Poll's case, used that evidence to prove the defendant's guilt, which this court determined was prohibited under Federal Rule of Evidence 408. Where it wasn't sufficiently clear whether Rule 408 testimony may have affected the outcome, this court vacated and remanded, and we submit that the same result should obtain in this case. Here, Mr. Molganicki's testimony was arguably more damaging than the testimony admitted in error in Davis, because Mr. Molganicki was permitted to testify not only about the fact that Mr. Poll had offered to repay this amount of money to, quote, get this all behind him, but further, Mr. Molganicki was permitted to testify about the effect that this offer had on him. He was permitted to testify that this was the last straw in his mind as to whether Mr. Poll had taken this money. And he further testified that he couldn't imagine that someone who had an honest right to that money would offer to repay it. That didn't make sense.
For prejudice purposes, which you're helpfully going to address, I mean, we have to take into account that evidence in light of all the evidence, right?
That's correct, Your Honor.
And what you're focused on now is the damaging capacity of this particular statement on its own. But in relation to all the evidence that's submitted on the relevant elements, you would have to show that there's a reasonable probability that the result would have been different.
Absolutely, Your Honor. And we believe that this erroneously admitted testimony rises to that level really for a few reasons. So first, Mr. Molganicki testified as the government's lead and star witness. So this was on the first day of Mr. Poll's trial, and all of the evidence that came in thereafter was really in the shadow of this damaging testimony about conclusive evidence of Mr. Poll's guilt. And then the government reminded the jury in its closing arguments about this meeting that occurred between Mr. Molganicki and Mr. Poll, where Mr. Craig was also present, and reminded the jury that this meeting was the moment that Mr. Poll was caught. So this was critical evidence in the government's case, and it went not only to Mr. Poll's offer to repay this money, but to his consciousness of guilt, which was the critical question before the jury. Did he have the requisite state of mind?
Did the closing argument, remind me, did the closing argument specifically talk about the offer to repay?
It did not specifically recite or re-recite that evidence, Your Honor, but it did refer back in at least 3 places to that critical meeting in January 2007 about which Mr. Molganicki was testifying when this testimony came in without objection. And the government at pages 1937, 1946, and 1947 of the record refer back to that as the moment that Mr. Poll was caught. So the government obviously placed great weight on this testimony and on Mr. Molganicki as a witness. He was critical to the government's case. He was the last chief of staff for whom Mr. Pohl worked when he served in Senator Kennedy's office.
Saying that it's the moment that he was caught is a lot different than saying it was the moment that he confessed guilt. Right.
I understand the distinction, Your Honor, but I would submit that it was the substance of Mr. Mulganicki's testimony that this was the moment that Mr. Pohl effectively confessed his guilt, was conscious of his guilt. And under Davis, we know that such testimony is plainly inadmissible, where it goes to the defendant's consciousness of guilt. In Davis, this court explained.
Well, the way that they knew that he was caught was when he confirmed that he actually did what they suspected him of doing, not him saying, "I'll repay you." I mean, that wasn't dispositive as to whether he was caught or not. It was him agreeing that, yes, he had made these transactions and he made them without authority.
Well, I would challenge a bit, Your Honor, the characterization that Mr. Pohl made them without authority, because the question before the jury was whether Mr. Pohl had a reasonable belief that he would have been able to issue these spend down bonuses to get Senator Kennedy's office budget as close to zero as possible every fiscal year, which he understood to be his mandate. And there was conflicting testimony about that January 2007 meeting and about what exactly Mr. Pohl may have said about the reasons for this money. So by way of example, Mr. Craig also testified at Mr. Pohl's trial. And when questioned, Mr. Craig explained that one of the reasons that Mr. Pohl had given was that he was reimbursing himself for expenses and that he had issued these bonuses in order to spend down the budget, which he understood was his mandate as Senator Kennedy's office manager. He understood that was Senator Kennedy's wish. And he had limited oversight and limited guidance in how to do that during his tenure as Senator Kennedy's office manager. And Mr. Craig also offered some testimony that conflicted with Mr. Mulganicki's version of events when Mr. Craig explained that Mr. Pohl had not, in fact, actually said that he had given these bonuses or made these transactions in order to compensate himself in a way that he felt he would have made more, for example, in the private sector. And that was consistent with Mr. Pohl's testimony when he testified at trial, when he also said, I never said that. I said, absolutely not. Could I have made more in the private sector? I understand that
the evidence wasn't all, I understand that there were, there was conflicting evidence and one could argue different inferences from the evidence. My point is that you are saying that when the government in closing argument emphasized this meeting and described it as the meeting as the time when he was caught, it was a meeting that they essentially characterized it as really like an intervention in where they confronted him with what had been done and tried to get his explanation for what had been done, and ultimately concluded that that wasn't a satisfactory explanation. All of in their mind. So all of that, none of that necessarily has anything to do with whether he agreed to repay the money.
I understand the distinction, Your Honor, but I would submit that the whole of Mr. Mulganicki's testimony was in the shadow of this early testimony that happened on the first day of trial about this offer to repay, which he said was conclusive evidence of Mr. Pohl's guilt. And yes, a lot happened in that meeting, and there was confronting Mr. Pohl about the spend down bonuses and where this money had gone. But ultimately, the critical moment was when Mr. Pohl offered to repay to, quote, get this all behind him. And Mr. Mulganicki said, well, that was the last straw. That was the moment that he became convinced that there was no good explanation for this, and that he couldn't imagine that someone who had an honest right to the money would make such an offer. And critically, under Davis, such testimony is plainly inadmissible, and trial counsel's failure to object to that testimony was constitutionally ineffective assistance. And it was prejudicial because we don't know whether such inadmissible evidence entered into the jury's consideration here. What we do know is that there was substantial conflicting evidence in this case. The district court explicitly said as much at Mr. Pohl's sentencing. The district court said there was conflicting evidence, conflicting testimony presented every day of the trial. There was scarcely a fact that was not in dispute. This is at page 23, 86, and 87 of the record, Mr. Pohl's sentencing transcript. So there was a lot for the jury to weigh. It was up for the jury to consider credibility of witnesses, to weigh conflicting evidence and come to a verdict. And we also know in this case that the jury struggled to do that. We have juror notes that say, we're having trouble reaching a unanimous verdict. Can we come back unanimous on certain counts and not on others? And so in light of this record, we would submit that it's not entirely clear that the jury, in fact, convicted Mr. Pohl based on evidence that was validly and properly before it. And for the reasons explained in our briefs and for the reasons discussed today, I realize that I'm out of time. We respectfully request that the court reverse the district court's denial of Mr. Pohl's motion for a new trial on the basis of ineffective assistance of counsel.
Can you direct us to any case where one evidentiary error has been sufficient to find prejudice under the Strickland standard?
I'm not aware of a case where one evidentiary, well, Davis, I submit was a distinguishable case because there was an objection there. Counsel did try to keep out this Rule 408 violative testimony, and so that was a harmless error analysis that the court performed. It was not a Strickland prejudice analysis. I am aware of cases, and we cite them in our briefs, where there were similar prosecutorial misstatements in closing arguments, which also occurred here regarding Mr. Pohl's oath of office, and other evidentiary issues that did amount to prejudice, and where a remand was the outcome.
Thank you, Ms. Stern. We'll give you a little time for rebuttal.
Thank you, Your Honor.
Mr. Sinha.
Good morning, Your Honors. May it please the court. Javier Sinha on behalf of the United States. Pohl's claims of ineffective assistance of counsel here lack merit because Pohl cannot carry his burden of showing there's actual prejudice to him in this case. Pohl's own words and actions show this. Pohl himself admitted in multiple email communications that he needed, what he was giving was bonus proposals or suggestions or recommendations. And in a memo to Mogilnicki, Pohl said that my role in this office is to give recommendations for bonuses, which the chief of staff must then approve. Pohl must have known he didn't have authorization for these bonuses. He gave them to himself for amounts much larger than were ever approved, and often before any approval discussions were even held. And Pohl repeatedly lied to chiefs of staff about these bonuses. He provided them spreadsheets that gave fake numbers that did not reflect the much higher bonuses he actually gave himself. He told Mogilnicki at one point that he had received between around $2,000 and $5,000 in bonuses last year when he had in fact received two $13,000 bonuses. And during the January meeting, he gave these shifting and conflicting excuses for why he had given himself these bonuses. My friend on the other side mentioned Davis multiple times. Davis did not discuss harmlessness. The government didn't raise harmlessness in that case. So it doesn't speak to the prejudice question in this case. And my friend on the other side also mentioned multiple times that it's not clear if the jury considered this, and it's not, she didn't know if the jury had thought this was important or not. To the extent that this is her burden to show prejudice, that just means Pohl hasn't carried his burden here. And indeed, Pohl testified at trial, and the jury was free to disbelieve him and consider that evidence as substantive evidence of his guilt.
Was he confronted with the statement that he offered to repay during cross-examination, or was that, did it come up at all?
It did not, Your Honor. I apologize. It did not, Your Honor. This was mentioned on the first day of trial briefly and was never mentioned again. My friend on the other side has mentioned this was brought up during closing argument. As Your Honor noted, the government brought up the January meeting to discuss Pohl's shifting and conflicting answers for why he had given himself this money, but it never mentioned his offer to repay. And indeed, this similar argument was raised in a district court, and district court found it misleading for this very reason. This testimony here wasn't a linchpin of this case. What this case was really about was Pohl's own statements and actions saying, I don't have authorization to do this without chief of staff approval. himself, giving himself these bonuses at a time when he could never have had approval for them. And then, of course, lying repeatedly to cover up his scheme.
What do you think the government was referring to in closing argument when they drew the jury's attention back to the initial meeting?
The government was discussing Pohl's, his excuses for why he gave himself this money. The first was that he was reimbursing himself, and the second was that he was trying to spread the money around to get to zero. So the government said this was, Pohl said these things. They don't actually make sense if you look at the record here. They don't make sense when you look at Pohl's repeated lies. But the government never mentioned the offer to repay again.
But why wouldn't the jury have concluded the same thing that Mr. Mogilnicki concluded, which is that if he offered to pay the money back, then obviously he knew he was not entitled to the money. So why wouldn't the jury have reached that conclusion after hearing that testimony?
That was Mogilnicki's opinion, but the jury, of course, was free to determine the significance of the offer to repay for themselves. Trial counsel here believed that this actually painted Pohl in a positive light because it showed Pohl acting in the best interest of the office. The district court, in its order, recognized that the jury here could have seen this as a positive thing, as Pohl saying, this is my money, but I want to work well with the office, so I'm happy to pay it back. Again, this is Pohl's burden to show.
The government didn't make that. I mean, it's not, if that were really apparent, then you would think that the government would have said a closing argument, that they would have used that fact as something in their favor. And they obviously didn't, for understandable reasons, the government would have done that, right?
Well, this was something that trial counsel believed, which is why trial counsel didn't feel a need to object to it. It's not clear the jury would have seen this as Pohl obviously admitting his guilt. Indeed, it wasn't very important at all to Pohl's guilt in this trial. As I mentioned, we didn't mention it ever again. What really was showing Pohl's guilt here was the things he said and the things he did that showed he knew he didn't have authorization, but he still gave himself the money anyway and hid it from the chiefs of staff for years.
Let me ask you about the restitution. I don't understand the government's position attempting to distinguish Huey and Hugo. They seem directly contrary to the award of restitution covering dates that were not in any indictment that the jury charged. And the jury was not told to look for a scheme. They were given specific dates. And that was all they found guilt on, those specific dates. And boy, when I went back and looked at Huey and Hugo, and I realized there's some other circuits that seem to go the other way, except in most of the cases that I read, they're distinguishable. They were dates that were different or whatever. They're not the same situation. It seems we've got Supreme Court decision. Restitution can be given only for the loss caused by the specific conduct that is the basis of the offense. The basis for the offense here was not a scheme, it was 5 dates. That's it. And we're talking about dates that are beyond the statute of limitation. On top of it would distinguish this case from other cases. Out of the statute of limitation, the government made a mistake in charging. It was not brought to, the jury did not see an indictment with more than the 5 dates. I don't know how you can read what the Supreme Court said and what we have said to allow you to seek restitution for dates that were not charged. You can't assume the jury found guilty. It was mentioned during the trial. That's not the same thing as charging.
So a few points on that, Your Honor. Beginning with Huey and Udo, neither of those cases dealt with crimes that involved as an element of the crime a scheme. And so those cases aren't entirely on point, but they are helpful. Here, what's important is the jury did find that Pohl engaged in a scheme to defraud.
If all we're talking about is scheme, first of all, part of this so-called scheme is out of the statute of limitations. Why list before the jury only 5 dates and nothing outside of the statute of limitations? It's the only thing the jury was confronted with.
Your Honor,
That's your mistake.
so restitution calculations are made by the district court. The MVRA explains that the district court makes these findings by preponderance of the evidence. And so the jury doesn't have to find.
You're supposed to follow what the Supreme Court said, right?
That's exactly right, Your Honor. We think we did that here. The jury here found
I don't know how you can think that. Restitution can be given only for the loss caused by the specific conduct that is the basis of the offense. The specific conduct that was the basis for the offense are 5 dates. There were other dates that were vaguely referenced, but not charged, nothing before the jury, that were outside of the statute of limitations period. And maybe that caused prosecutor to hedge the bets, but in any event, they were not before the jury. Now, I don't know how you can read Huey and say that, well, you can take into account other possibilities, even though that was really not the case before the jury.
I'll make a few points. The most important of which I think is that Huey predates the MVRA and the changes made in that statute. That statute clarifies that victims get restitution, and victims include those directly harmed by conduct in the course of a criminal scheme, which shows that restitution is given for conduct in the course of the scheme, whether that scheme falls out or whether that conduct falls outside the limitations period or not. And so that being said,
Hugo says you can't reach uncharged events.
so we're not reaching here uncharged wire fraud counts. It doesn't matter whether the wire fraud counts could have been charged or not, because what we're reaching here is Pohl's conduct as part of the scheme that
The jury
occurred.
was not asked to find scheme or no scheme. That's not the question that was before the jury. The jury has 5 dates.
The jury was asked to find a scheme, Your Honor, and that scheme is an element of the crime. And so here the elements of the wire fraud are, there's a scheme to
The
defraud.
scheme that the jury thought it was considering included 5 dates. That's it.
Well, those were executions of the scheme, which is a separate part of the separate element of the wire fraud count.
Yeah, I'm glad you're smiling at that, because I don't think that's a winning response. You said there's a scheme, and what's the scheme? 5 dates, that's it.
You know, I think those are
The jury's
executions.
supposed to guess about the rest?
So the jury finds a scheme, and it finds the executions of the scheme that happened on or about those 5 dates. But the determination of what conduct falls within the scheme is for the district court to make under the MVRA. Section 3664E explains district court makes fact findings that determine the scope of the scheme and the amount of restitution, which is what happened here. Here, the jury found a criminal scheme.
Statute says the district court judge can find guilt on the basis of something that was never considered by the jury. I don't think so.
The judge isn't finding guilt here, Your Honor. The judge is finding whether or not the conduct that Pohl engaged in was part of the criminal scheme for which the jury already found guilt. So that's what
Was
happened.
the jury instructed on what the scope of the scheme was, as far as from this date to that date, or any other limitation?
It wasn't. It was given a limited verdict form that only included these 5 dates. And that's partly because Pohl asked the jury not to be given the indictment, because Pohl believed the indictment had a lot of extra information that he didn't want the jury to
The
see.
answer is no. The jury did not. To my colleague, the answer is no.
Correct.
Okay.
So the jury didn't have those dates before them, partly because of Pohl's insistence the jury not be shown the indictment in the jury room. But what matters here is that the jury found that Pohl engaged in a scheme to defraud, and the district court then found at the hearing that this was all part of the same criminal scheme, all of Pohl's conduct was part of that same scheme for which he was charged and convicted. And because of that, the MVRA requires restitution for that conduct.
So let's suppose Pohl, prior to Senator Kennedy, had also worked for, another senator. And in investigating this, they found that he had been doing this for 25 years. None of that was put before the jury, but at sentencing, can the district judge, on the government's request, look at all of that going back 25 years and say restitution because it's all part of the same scheme?
It depends on a number of factors. If the government has to charge it in the indictment, of course, sets the outer limits. But if the indictment charges the outer limits, then as long as the district court, the government has a burden to prove this by preponderance of the evidence. So as long as the district court makes the findings by preponderance of the evidence that Pohl's conduct was part of the same scheme for the entire 25 years, then the government can get restitution for that. And in fact, it's required by the MVRA. And we cite some cases in our brief on page 54, I believe, that go back 15 or 17 years. The limitation on restitution is really about the defendant's conduct. The longer and broader the defendant's criminal scheme is, the more the MVRA requires that he pay. And so,
How do we understand the parameters of the scheme? What tells us what the parameters of the relevant scheme are?
so the outer limits are in the government's indictment, because he can only be charge restitution for what he has been charged for. And once the indictment limits the beginning and the end of the scheme, then the district court's fact findings by preponderance of the evidence determined what conduct was within that scheme.
And here, how did the indictment describe the scheme?
It's beginning in 2003 and ending in 2007 when.
That's not what the jury saw.
No, the jury did not see that. The government argued this in closing argument, and there was evidence in the trial about that. The jury was simply asked to find a scheme, and that.
The jury was not. The jury was asked about 5 dates. That's what the jury, don't change the facts. The jury was asked about 5 dates. That's it. And you want to make, as did the district court, want to make scheme cover anything, whether or not the jury considered it. And what's really kind of astonishing here, it's out of the statute of limitations.
We cite to numerous cases on page 54 of our brief. Other courts have found this. This is the Parnell case.
I mean, I can run you down most of those and they're distinguishable.
I think what's important here is that the jury finds a criminal scheme, and the MVRA says after that, it's for the district court to determine what the restitution is by determining as part of that what conducts fall.
You keep saying the jury found a scheme that didn't. The jury found guilt on 5 occasions. That's all they were presented.
Well, one of the elements of guilt for wire fraud, Your Honor, we may just simply disagree on this, but one of the elements of wire fraud is that there was a criminal scheme. The next element.
I guess the question is, at least in my mind, is I think you're right that the jury has to find a scheme to convict on wire fraud.
Mhm.
But so the word scheme is used in the jury instruction. I take it was here.
It was.
But that doesn't necessarily tell us that the jury's finding the same scheme that was encompassed by the indictment. So as I understand the theory, it's that the jury has to find some scheme to convict of wire fraud. And that scheme could be a scheme that's confined to the particular incidences of fraud that are put to the jury. So it could be a scheme that envelops 5 specific incidents. The indictment could encompass 20 incidents because it dates back 15 years behind that. So the scheme that's found by the jury could be more confined than the scope of the scheme that's found by the jury could be more confined than the scope of the scheme that's encompassed by the indictment. And I think that just has to be true. And then, but your submission is, that's okay. Because as long as the indictment covers the larger scheme, anything within that larger scheme can be included as part of restitution, even if it's larger than the scheme that the jury found in determining that there was wire fraud. Is that your position?
That's basically right, Your Honor, yes.
So then your position has to be, it isn't, just to follow on to Judge Edwards' questioning, it isn't that the jury found the scheme that would support the restitution award. It's that the jury found a scheme. That scheme may be a narrower scheme than the one that would support the restitution award.
Right.
That doesn't matter, because as long as the scheme that's in the indictment supports the restitution award, that's all that matters from the government's perspective.
That's correct. As long as the district court makes findings under the MVRA that scheme in the indictment matches what he finds to be part of the scheme, then that's all that matters.
So it would be, the restitution award is supported by a scheme that ranges, or at least can be supported by a scheme that ranges beyond the scope of the scheme that's found by the jury.
That's theoretically possible. Of course, we don't know what the jury found, but yes, the indictment limits the outer scope of the scheme, and then the district court makes findings for restitution, which can include conduct in the course of the scheme that maybe the jury didn't consider or think about.
And then it seems like there would be, and I think we noticed this in our prior opinion, there could be an Apprendi issue about the jury's findings supporting the scope of the scheme that leads to the restitution award.
Pohl hasn't raised that in his brief, and so I think that's been abandoned and waived, and this court shouldn't consider it. That being said, every court to have considered that issue has found that there is no Apprendi issue. Apprendi limits judge-made fact findings that raises the statutory maximum. And restitution has no statutory maximum. It's a variable amount that changes based on the defendant's conduct.
And do you understand there to be an argument in this case before us that the jury didn't find the relevant, put aside the Apprendi issue just for now, because I think that's a gloss on this, but that the jury, although the jury found a scheme, they didn't find the relevant scheme that would support the restitutionary award?
I don't see that raised in the defendant's brief, Your Honor. I don't think that's before this court. And so I don't think this court needs to consider that. But I think even if that were before this court, as long as the jury found a scheme here, it's the district court under the MVRA to find, by preponderance of the evidence, what conduct fell within that scheme. And if it does, the MVRA requires restitution for that conduct.
But the district court didn't find that the district court didn't purport to find that the scheme found by the jury encompassed all of the conduct dating back
Nope.
before the statute of limits, right? The district court didn't, because the district court didn't think that it had to do that.
Oh, the court said that all of the conduct was part of the scheme that was charged and convicted, but the court didn't say the jury found necessarily a scheme this long. The district court couldn't know that.
Right, because the jury, we don't know what exactly the parameters of the scheme that the jury found. We know that they found a scheme,
Correct.
but we don't know the parameters of that scheme because
Correct.
they didn't have evidence about the full scheme that was alleged in the indictment before it, so we can't know.
That's correct, Your Honor. And the jury wasn't asked to do that. That wasn't something that the jury needed to be asked about. And so the jury found the 5 executions of the scheme, but it didn't actually make findings about the length of the scheme. And part of that is because, of course, the indictment wasn't sent back with the jury, showing all the extra evidence that Pohl didn't want the jury to know about because it was outside the limitations period.
So you say that as long as the scheme described in the indictment, that restitution can be ordered for all acts that fall within the scheme described in the indictment, right?
That's correct.
Is that from the MVRA text or where does that come from?
That essentially comes from Huey and Udo and those line of cases that say that the restitution must be for the crime charged and convicted. And so if it hasn't been charged in the indictment, it can't be encompassed within the restitution order.
Even though the jury's never seen the indictment.
That's correct, Your Honor. As long as he was charged with it and its conduct underlying the crime he was convicted for, Huey allows that. And the MVRA, of course, explains that it includes restitution for conduct throughout the course of the scheme.
Did you say charged and convicted?
He has to be convicted for a scheme. So part of the conduct is, was he convicted of a scheme here? It's a scheme-based offense, and that's what matters under the MVRA.
But I thought you said in describing where we get this from Hugo and Udo that those cases talk about the scheme that was charged and convicted.
I may not be clear about my language, but it has to be the conduct underlying the offense, I should say. That's what the language that Huey uses. And so conduct underlying the offense has to be, of course, charged in the indictment. But once it's charged in the indictment, then the district court can make fact findings to determine what conduct, by preponderance of the evidence, he believes falls within that scheme.
So could a district court do the following? Could a district court say the scheme alleged in the indictment covers 20 acts. The scheme presented to the jury covers 5 of those 20 acts. I find that the scheme that was necessarily found by the jury in rendering the conviction was confined to those 5 acts. So that's what was found beyond a reasonable doubt. But I find by a preponderance of the evidence that the scheme charged covers 20 acts. And I mean, I guess the government could present evidence in sentencing that says that all those acts were proven by a preponderance of the evidence. And so by preponderance, that entire scheme existed. And therefore, I'm ordering restitution as to all the 20 acts.
The court could do that, Your Honor. I think the court has to do that under the MVRA because the MVRA says if you're a victim, you get restitution, and then says victims are people who are harmed by a criminal scheme, by the course of conduct in a criminal scheme. So the court would
Didn't we say in poll 1, the government can always ask the district court to craft a verdict that ensures the jury is able to make factual findings sufficient to support a particular amount of restitution?
This court said that, and then it said, or if there's no Apprendi problem, it can simply have the jury make the appropriate fact findings. The court there.
Yeah, there was no.
Judge.
I'm sorry, I missed.
Sorry.
Go ahead. No.
There was no such fact finding.
The court did find here that all of
Jury.
The jury didn't make this fact finding.
No, right, because the jury didn't know it had more than 5 events before it.
But based on this court's language in poll 1, the court said either that or assuming no Apprendi problem, which this court should assume for this case as well, since it hasn't been raised, the government can ask the court to make these fact findings. And so the government did that. The court did find that all of Pohl's bonuses here were part of the same criminal scheme, and so ordered restitution for all of them.
What would be wrong with the rule that said, look, if you intend to ask for restitution beyond specific acts that the jury find, then in your scheme instruction, you say you must find that there's a scheme from date 1 to date 2, and you just set forth the date range
For the jury.
for the jury.
I think
What would be wrong with requiring that?
I think a couple things. The first is that Huey says that restitution is a creature of statute. And the statute here, the MVRA says, these are findings that are made by a judge by preponderance of the evidence. And so a jury doesn't have to actually make the finding about the length of the scheme here. That's a finding for the court to make by preponderance of the evidence. And so it'd be strange to have a jury make a finding beyond a reasonable doubt that the judge would actually have to make by a lower standard. The second problem is I think there's a lot of defendants, Paul I think was one of them, who doesn't want the jury to think about how long running this scheme was. And so I think defendants would have problems with that as well. But I think the biggest problem here is that it would run sort of counter to the language of the MVRA.
And just to clarify, the statement in our prior opinion was that the government can always ask the district court to craft a verdict form that ensures the jury is able to make factual findings sufficient to support a particular amount of restitution.
Right.
Or assuming no apprendee problem, urge the court to resolve factual disputes. I think you might have said jury on the second one, but what we said, we hypothesized that the court.
I apologize. I meant the court, yes. And so the court, I think, was giving two options based on whether there was an apprendee problem here. Again, there's been no apprendee issue raised, and so the court's findings here are sufficient under this court's decision in Poll 1 to find that the scheme encompassed.
I mean, clearly, if there was an apprendee issue, if you're wrong about the apprendee issue, then obviously what happened here can't be sustained because the jury, we'd have to know that the jury found beyond a reasonable doubt that the scheme encompassed the full range of events.
I think that's right, Your Honor. Again, there's been no apprendee issue raised here. We don't think apprendee applies for the reasons I've discussed. But there's an apprendee issue. This is a different case entirely. There, of course, isn't one here. And so the question simply is whether, the course of conduct included the harms that the court considered within the scheme that jury.
So for purposes of our case, if the government were to prevail on this issue, we wouldn't have to say that the government is right that there's no apprendee problem.
That's correct.
We could assume a world in which there isn't an apprendee problem, but leave open whether there in fact is a requirement that the jury make the findings about the parameters of the scheme. In which event this case, had the apprendee issue been raised and preserved, would come out differently.
That's exactly right, Your Honor. That's exactly right.
So trying to make sure I understand the government's position and how you construe the statute. Let's suppose the jury had been instructed that the scheme was in 2004 and 2005. So that was the instruction that was given to the jury. Maybe it was done inadvertently, but that's the instruction that was given. And so when they returned their guilty verdict, that's the scheme that they found. Is it your position that it doesn't matter? The district court at sentencing could still order restitution beyond 2004 and 2005?
I think it is, Your Honor. I think the idea is that the jury found a criminal scheme by a certain standard, which is beyond a reasonable doubt. But the district court standard is lower, it's preponderance of the evidence. And so even if the jury didn't find this, the district court still could. And so as long as the indictment includes that within the indictment, the district court could find under 3664.
Even if the jury was instructed, are you answering the question my colleague asked? The jury was instructed, the scheme that occurred in 2004 and 5, that's consistent with what the jury had already seen. And you're saying even in that situation, you can go outside of those dates into a period not covered, doesn't meet the statute of limitations, never presented to the jury, and in the instruction before they begin deliberations, they're told it's only 2004 and 5.
That's correct, Your Honor. They're two different
Who
inquiries.
says that?
I mean, it's this argument we're making
Other than
now
you?
based on the text of the MVRA.
But
Which-
the text of the MVRA, you tell me if I'm reading it. So 3663A, and then let's look at A2.
Mhm.
Is that the relevant text?
That's correct, Your Honor.
It says, victim means a person directly and proximately harmed as a result of the commission of an offense for which restitution may be ordered. So what does it mean, harmed as a result of the commission of an offense. If the offense was defined for the purposes of my last hypo as a scheme from 2004, 2005, isn't it a different offense to order restitution for things that happened outside of that time period? How is that the same offense?
I think what matters here is that there's different standards. And so the jury may have found on a reasonable doubt that the offense went from 2004, 2005, but the district court finds by a lower standard that the scheme went longer than that. I think it's a different question for a different fact finder, which is the main issue here.
So you're trying to liken this to like acquitted conduct or something where, you know, it can still be considered at sentencing as long as there's finding. I'm just trying to understand exactly how you think we should construe this statute and understand the word commission of an offense.
I think there's a few points. I think one of the changes the MVRA made after Huey was that it used to just say an offense, and it was changed to commission of an offense, which courts have said tries to broaden the reach of the statute. And the second thing I'll say is that the MVRA says a victim is any person directly harmed by the defendant's criminal conduct in the course of the scheme. And because it's a different inquiry, the jury has to find the crime, but the district court finds restitution for restitution purposes. The district court can make findings that are broader than the district court had, than the jury had to make.
So I think to me, and I don't have the full statutory language in front of me, but I see it on excerpts quoted at page 51 at least. It speaks in terms of an offense involving as an element a scheme. And then a victim is any person directly harmed by the defendant's criminal conduct in the course of the scheme. So the scheme and a scheme refer to the same scheme.
Correct.
So if the offense involves as an element a scheme, and that only deals with what's in the indictment as opposed to the scheme found by the jury, then I take it could be the case that if the jury acquits on a wire fraud count, then under your view, the government could still say, well, the offense involves a scheme and the person directly harmed by the criminal conduct in the course of that scheme is a scheme that we can show by a preponderance of the evidence, even though the jury acquitted on the existence of the scheme beyond a reasonable doubt.
That's correct, Your Honor. Of course, none of this happened here. Here, he was found guilty on all 6 counts, and the indictment did list the entire scheme that we seek restitution for. But that's correct.
But I think the fact is that if we assume that the scheme that was put before the jury is narrower than the scheme that's in the indictment, then that breaks down to the same thing as ultimately as the jury finding the existence, the jury declining to find the existence of the scheme that the indictment alleges.
I think it's partly right. I don't think the scheme put before the jury was less than the scheme in the indictment. I think the jury wasn't asked to make findings in the verdict form based on everything that's in the indictment, but the information from the indictment beginning in 2003 was presented to the jury. The jury saw exhibits discussing Pohl's actions in 2003 and 2004. And the government's closing argument mentioned the $75,000 Pohl stole, which is the entirety of the amount from 2003 and 2004, including 2007. And so the jury here is presented with evidence of the entire scheme.
Right, but we don't know the scope of the scheme that the jury in fact found because it wasn't required to define the parameters of the scheme in order to convict a wire fraud.
That's correct,
We just
yes.
don't know.
And the verdict form is limited to 5 events.
It's limited to the 5 executions of the scheme that were charged here. I'm happy to answer more questions, Your Honors, but if there are no more.
You're happy?
I'll rest on our briefs then if there are no more questions. Thank you very much.
Thank you, Mr. Sina. Stern will give you 2 minutes for a rebuttal.
Thank you, Your Honor. I'd like to briefly address 3 points that the government raised in its argument. First, as to this idea that the failure to object to Mr. Mogilnicki's Rule 408 violative testimony was somehow strategic by trial counsel, and that maybe this was positive because it painted Mr. Pohl in a positive light. That's completely contradicted by the declaration that trial counsel submitted in connection with the evidentiary hearing that occurred on remand in this matter. Trial counsel explained in his declaration explicitly that there was no strategic reason for his failure to consider Federal Rule of Evidence 408 and to object to this testimony. He simply didn't consider the application of this rule during Mr. Pohl's trial, and that's in the record at 2814 to 15. He also testified consistently at the evidentiary hearing in this matter when he said that if he had known that Rule 408 prohibited this testimony, he would have had it taken out. And I believe that's in the record at page 3067. So the second point I'd like to make is that the government mentioned actual prejudice to Mr. Pohl. My colleague briefly addressed some of the evidence in the record. The point here, respectfully, is that there was conflicting evidence in the record that the jury had to weigh. The jury had to consider competing testimony and determine whether Mr. Pohl possessed the requisite state of mind. That was the critical issue. And then third, I'd like to address this idea that there was only one evidentiary issue that prejudiced Mr. Pohl. There were at least two, and those are not just Mr. Molganicki's Rule 408 violative testimony, but the government's use of Mr. Pohl's oath of office in its closing argument. That was evidence that was never admitted at trial. It was plainly inadmissible, and it also went directly to this question of Mr. Pohl's state of mind, so it should never have been before the jury. And those compounding errors of improper evidence, in our view, infected Mr. Pohl's trial and are a basis to reverse the district court's denial of Mr. Pohl's motion on the basis of ineffective assistance of counsel. And I see that I'm out of time, so I thank the court for its attention.
Thank you, counsel. Thank you to both counsel. Ms. Stern, you were appointed by the court to represent the appellant in this matter, and the court thanks you for your assistance.
Thank you so much, Your Honor.
That occurred to me because it was so clear.
Case number 23-5204. Ryan Castaneira, appellant, versus Kristi Noem, Secretary for the Department of Homeland Security in her official capacity et al. Mr. Castaneira for the appellant, Ms. Beach, appointed amicus curiae for the appellant, Ms. Hummel for the appellees.
Good morning. Mr. Castaneira, hear from you first.
Good morning, Your Honors. Mr. Chief Justice, may it please the court. I'm Ryan Castaneira. I'm humbled to be appearing here pro se. Congress enacted the Adam Walsh Act in 2006 in order to protect children from dangerous offenders. As part of that effort, Congress made minor adjustments to the immediate family relative status adjustment process of the INA. Congress removed a subset of those petitions from the Attorney General's purview and entrusted a gatekeeping, no-risk determination to the discretion of the Secretary of Homeland Security. Congress did not grant unbounded discretion for that determination because, among other things, it left legal determinations squarely to the Attorney General. The district court erred in concluding that the Secretary's discretion includes disregarding settled questions of law and binding regulations and could thus trigger a jurisdictional bar. I welcome the court's question.
So how do we know that Congress intended to allow review of the standard of review as opposed to considering that to be within the Secretary's discretion?
Well, I think, Your Honor, the Supreme Court handled that in Kukana when it addressed this particular jurisdiction stripping statute, and it gave massive effect to the language specified in subchapter 2 of the INA. And subchapter 1 is the power allocating provisions of the INA, which conferred upon the Attorney General and only the Attorney General to determine questions of law. And it states specifically that those are binding in the execution of the INA. I don't believe Congress silently changed that statutory scheme with the minor adjustments it made to the family petition process.
Here we have two separate statutes that talk about unreviewable discretion. We have the provision in, I guess it's 1154 about sole and unreviewable discretion. And then we have 1252 that says decisions in this subchapter, which 1154 is part of, shall not be subject to judicial review. And there, I believe that the statute uses the terms decision or action. So we kind of have two separate instances where Congress makes clear that these sorts of, that a decision or action, or that that the determination or determines shall not be subject to judicial review. Aren't those all pretty broad words? Decision, action, determine?
I believe they are pretty broad. It's pretty broad language, yes, Your Honor. However, in the jurisdiction stripping provision, again, we are confining ourselves only to subchapter 2 of the INA. And in subchapter 1, which is what sets up the power allocating scheme between the executive actors of the government that execute the INA, the Congress found no reason to grant the Secretary discretion over matters of law that are settled by the Attorney General, and specifically says that they're binding. So, you know, as you know, it is the purview of these courts to construe statutes. And I don't think Congress intended with that language to write a statute, never for the court ever to construe it, ever to see what its actual breadth is.
Thank you.
Can I just ask, under your argument, under this part of your argument at least, it wouldn't necessarily mean that the Secretary would have to make a different determination. It would mean that the Secretary would have to make the determination anew, but then could reach the same conclusion?
He absolutely could, Your Honor.
Okay.
Absolutely. However, if you read the actual denial notice that the Secretary put out in this case, you can see that he uses a standard of proof that is not what regulation or the Attorney General has determined is appropriate. So I think he would have to begin anew that determination process confined to those parameters.
I'm sure my colleagues don't have additional questions for you, Mr. Castaneira. Thank you.
Thank you, Your Honor.
We'll hear from the amicus now.
Good morning, Your Honors, and may it please the court. My name is Kate Stetson. I am here this morning in my capacity as a supervising attorney for the Appellate Litigation Clinic of the University of Virginia School of Law, and I'm pleased to introduce Cameron Beach, who will be arguing for amicus.
Thank you. Speech.
Good morning, Your Honors, and may it please the court. You heard briefly from Mr. Castaneira about one of the legal issues today. I'd like to discuss fully the three issues that are presented on appeal. The first concerns jurisdiction, as you heard from Mr. Castaneira. The second, the Accardi Doctrine, and the third, the substantive scope of the Adam Walsh Act. Now, we think that the district court had jurisdiction to review Castaneira's Accardi claim, but we also think that the Adam Walsh Act doesn't apply to his conduct at all. So I'm going to begin, as the briefs do, with jurisdiction, but I'd be happy to move to that third argument as the court is interested. On jurisdiction, the district court declined to review Mr. Castaneira's federal claims because it reasoned that two statutes, the Adam Walsh Act, and the Illegal Immigration Reform Act together barred its jurisdiction. But that conclusion defies the plain text of the Adam Walsh Act and ignores relevant Supreme Court precedent. I'll start with the act itself and the Form I-130 process here. The agency generally grants these Form I-130s unless it finds that the petitioner had previously been convicted of a specified offense against a minor. In those cases, the Adam Walsh Act directs the secretary to, quote, determine that the citizen poses no risk to his or her beneficiary. In turn, Congress has committed that determination to the secretary's sole and unreviewable discretion. Now, the Supreme Court in McNary versus Haitian Refugee Center has told us that when Congress commits a, quote, determination to the secretary's discretion, that grant of unreviewable discretion protects only the secretary's final decision on the merits from judicial review. It does not protect what the Supreme Court called in McNary, quote, general collateral challenges to illegal policies used by the agency in processing applications. So too here. Now, to evade McNary, the government argues that the word determine, as used here in the Adam Walsh Act, is somehow vastly different from the word determination, as used in the statute at issue in McNary. The government argues that that word determine shrouds all of the secretary's legal determinations and unreviewable discretion, as it does the final choice on the merits. Now, that's a lot of weight to put on the word determine, and that's not what the word means. Your Honors, the plain meaning of the word determine is to fix conclusively or authoritatively, to settle a question or controversy. The word connotes finality.
I mean, I think one thing that is a little tricky for your submission, I think, relative to some of the language that you understandably rely on for some of the decisions is if there's a part of the process that is collateral, to use the word you used, that may be one thing. But it's a little more difficult to think of the burden that goes directly to the conclusion as being truly collateral in that same way, because it seems intimately bound up with the conclusion. The ultimate determination here, which is in the secretary's sole and unreviewable discretion, and as you acknowledge is in their sole and unreviewable discretion, is if the citizen poses no risk. And it's just hard to think of that no risk calculus without thinking about the threshold for making the no risk calculus. They seem intimately bound up with each other. So even if you could draw a distinction between matters that are collateral and the ultimate determination, this one seems tighter.
I think you can draw that distinction, Your Honor, and I'd actually point you to the Supreme Court's decision in McNary itself, where the Supreme Court drew that same distinction. And what the Supreme Court did in that case was to look at the effects of the challenge should the plaintiffs have won. If the effect of the challenge, as you pointed out when you spoke with Mr. Castaneira, Chief Judge, if the effect of the challenge is to fully grant the plaintiff a win on the merits, let's say an arbitrary and capricious challenge to the ultimate decision, then that's clearly a direct challenge that would fall under the jurisdictional stripping bar in this case. But what the Supreme Court said in McNary, that if the plaintiffs there were allowed to prevail, they'd only be entitled to have their applications reconsidered in light of newly prescribed procedures. That's the type of collateral challenge, you could call it a predicate challenge. That's the type of challenge that we're talking about here today. If Mr. Castaneira is successful, he only gets the opportunity to go through the agency's process with the correct procedures in place this time. And so because it is not outcome determinative, it is probably thought of as a collateral challenge, a predicate challenge, something that exists separable from the ultimate decision.
Suppose you have the following kind of scenario. The secretary sets out 3 considerations that are going to factor in the decision of whether to grant this discretionary relief on the criterion of no risk. There's 3 considerations that are going to inform the decision. There's a factual context in which those 3 considerations are applied, and the determination is made that the no risk calculus has been met. And then in a subsequent case, the secretary applies that and says, okay, we've had this 3 consideration framework. I'm going to apply the same 3 considerations, but I'm going to reach the conclusion that actually the no risk threshold has not been satisfied, so I'm going to deny the discretionary relief. And then the challenger says, the person who's affected directly by that decision brings a challenge and says, look, there's those same 3 considerations. There's no rationale for reaching a different conclusion in this case. If you apply them in any faithful way, you've got to conclude that the same result obtains because you haven't pointed out a relevant distinction from the last time. And then let's suppose further that they say, now I understand I can't get a direct result here that reverses. So what I want you to do is to order that the secretary considered it again, because it looks like these same three considerations, if applied faithfully, should reach the same result as last time, which is the grant of relief as opposed to the denial of it. Now, again, the challenger has said, I'm not asking for the result to be reversed. I know I can't do that, but I'm just asking for a new look, because I'm pretty sure that if you apply the same three considerations faithfully, you're going to reach the right result. Is that something that we would consider to be beyond the jurisdictional bar?
I think that's a closer case than what we have here, Your Honor. But I think if the challenge truly is a predicate challenge in the way I described, it's truly not going to change the ultimate decision on the merits, it's not attacking the ultimate decision on the merits, then I think under our conception of the word determined, this court would have jurisdiction to review it. But, I think what you're pushing on with that hypothetical is the idea that the immigration bar is maybe going to try to exploit a loophole here and try to shove cases into the predicate garb when they're really actually substantive. I think holding for Mr. Castaneira today doesn't necessarily mean that type of challenge you can't hold the other way. But if this becomes an administrability issue and the immigration lawyers start exploiting these differences, there's a solution. Congress can change the statute. But I don't think we should alter the text of the statute as written to accommodate the possibility that the bar will abuse the proper meaning of the word determine. Now, I want to point out briefly that the Supreme Court has given Congress a roadmap of how to bar these purely legal, purely collateral types of questions. And they did so in McNary. The Supreme Court in McNary said, if you want to bar collateral challenges like this, take a look at the Veterans Judicial Review Act. That statute commits to the Secretary of the VA, quote, all questions of law and fact necessary under laws that impact the provision of benefits to veterans. And then in the same sentence reiterates that those decisions as to law and fact are unreviewable. That's the type of clear language the Supreme Court said would bar collateral legal challenges like the one we have before us. The word determined just isn't enough. Now, McNary was decided in 1991. Congress didn't pass the Adam Walsh Act until over a decade later in 2006. It knew how to thoroughly insulate a decision from review based on that roadmap that the Supreme Court gave it. And instead it used the word determine. I think it's important here to reflect that we're really debating over the difference between the noun and the verb form of this word. Indeed, the government's hinging a big jurisdictional consequence on that difference. If the government is right and Congress truly meant something so different by using the word determine instead of using the word determination, then USCIS can conceivably reject all applications filed on a Friday. They can reject all applications filed by people from Connecticut. And of course, those are the sorts of arbitrary decisions that this court would instantly strike down as an abuse of discretion should it have jurisdiction, but the government is saying that you don't. I don't think that's right. And I think that's where it's prudent to consider the strong presumption in favor of review of administrative
Is it
action.
undisputed that the beyond a reasonable doubt standard is wrong? Is it undisputed?
It is undisputed that the agency used the beyond any reasonable doubt standard in
know.
this case.
Is it undisputed that that was error?
It is, the government does not contend that the decision, that the Administrative Appeals Office decision in matter of Chuaith is not binding. The decision is binding. So, and that decision, of course, says you must use a preponderance standard when evaluating.
Your answer to me is the government hasn't disputed your assertion to that effect. Your answer
No.
is not that everyone agrees that beyond a reasonable doubt cannot be used. That is, I'm just trying to figure out how strong you think that position is.
The government does dispute that the matter of Chuaith opinion applies, but it does not dispute that it is binding. We, of course, believe that the matter of Chuaith opinion that requires the preponderance standard in this case does apply. So that's where the dispute is. Your Honors, I see that my time is out, but I do want to make sure we talk briefly about the second way that this court could reverse the district court in this case, and that is the scope of the Adam Walsh Act. Is that okay with Your Honors to go there now?
We'll give you a minute just to.
Thank you, thank
summarize
you.
that argument.
We think the Adam Walsh Act doesn't apply to Mr. Castaneira's conduct at all, and we talk about the two approaches that this court could take to that question in our briefing, but no matter which one this court applies, Mr. Castaneira's actions don't fall under the umbrella of the Adam Walsh Act at all. The Adam Walsh Act requires the petitioner to have been convicted of a specified offense against a minor. That is the hook of conviction from which all of these downstream consequences flow. Mr. Castaneira's actions don't fall under that definition because he did not commit a crime against a minor. Congress made it very
I don't
clear.
understand how you can make that argument when the Georgia Court of Appeals decision in like the opening paragraph lists the convictions and then in a footnote lists what statutes were the subject of the convictions, and then in the one statute it says offense against a minor in the statute.
So the statutes that Mr. Castaneira were convicted of can all be violated under mere belief that the person that he was talking to was a minor. And so that's the reason under both the categorical approach, which we believe is the appropriate approach here, or the circumstance-specific approach, that's the reason why his crimes don't fall under the umbrella of the Adam Walsh Act, because Congress has made it clear that minor is an identifiable legal term, someone under the age of 18 in the statute. And because Mr. Castaneira didn't commit a crime against a minor, against someone under the age of 18, he should not have been subjected to the agency's no-risk determination at all. For those reasons, if there are no further questions, we respectfully ask this court to reverse and remand for further proceedings.
Can we go back to the jurisdictional issue for a moment? And you say in your brief, and you said this morning that determine and determination mean the same thing, and that the definitions of determine, really the prevailing definitions are the ones we should care about, are about the ultimate decision. But there are lots of dictionaries, contemporary dictionaries, that use language like determine means to come to a decision by investigation, reasoning, or calculation. Why isn't the process of reasoning or calculation, why isn't that equivalent to like the standard of review or your procedure or your methodology for reaching the ultimate decision?
I think Your Honor points out that both I and the government can find definitions that support our view of the scope of the word determine. But I think what's a little more helpful here is looking at the way Congress uses this word throughout the immigration code. I'd point you to the asylum claim statute. Quote, if the Attorney General determines that an alien has made a frivolous application for asylum, the alien shall be permanently ineligible for benefits effective as of the date of that determination. So in the same sentence, Congress directs the Attorney General to determine something and then immediately refers to that as his determination. I think that's what makes it clear that when Congress is using this word in the immigration code, it's referring to finality. It is giving a command to reach an output. Frankly, I think the way Congress uses the word determine is basically the same legislative shorthand as make a determination. If you substituted make a determination here, the statute would mean the exact same thing. Your Honors, if there are no further questions, we respectfully ask this court to reverse.
Thank you. I'll give you a little time for rebuttal.
Thank you.
Hear from the government now. Ms. Hummel.
Good morning. May it please the court. This court should affirm the district court's sound holding of the Adam Walsh Act and Section 1252A2B2 bar judicial review of both the process and the ultimate determination in a no-risk determination. As the district court stated, Congress's grant of discretionary authority could not be much clearer than the statute's language, which grants the secretary sole and unreviewable discretion to determine whether a Form I-130 petitioner convicted of a specified offense against a minor has established that he presents no risk to the intended beneficiary. The statutory language in the Adam Walsh Act and in Section 1252 are clear. All circuits to have considered the issues before this court today have reached the same conclusion as the district court below. And I think as a matter of context, it's helpful to remember that under the Adam Walsh Act, the default is that an I-130 cannot be granted for an individual convicted of a specified offense against a minor. So what this case is addressing is actually the exception to that statutory bar on granting. So whether he Mr. Castaneira falls within the exception, which would be an exercise of the secretary's grace to allow the petition to be approved.
Isn't that always the case when we're talking about 1252 A to B? It's about denial of discretionary relief, right? So
Yes,
we're always talking about a situation in which the default may be pointing in the other direction, but there's the denial of a discretionary form of relief.
yes, for 1252 A2B2, yes,
Right.
and 1. But in this case, we're looking at subsection 2. And we think that the text of both of those statutes is clear that the process, which would include the burden of proof that the secretary applies in making the determination, fall within that statutory bar against reviewing discretionary decisions. This is supported by the Act's text, its grammar and structure, and its history. Looking at the text, the difference between a noun and a verb is significant. Here, where the statute says determines, that is the act of determining, which would include the entire decision-making process. A determination would refer to a single decision or the ultimate outcome. And that is reflected in McNary. In McNary, the statute at issue, the statutory language was a determination respecting an application. That was the discretionary determination. So the court found that it could still review because that challenged a pattern or practice of procedural due process violations. So that is how they got around the jurisdictional bar in McNary. But here, again, we have determines and we have individual claims. So the bar does apply.
So then the government acknowledges that if the statute said makes a determination instead of determines, that the result would be different in this case.
Yes. But because it says determines, it does fall within the statutory bar. And the grammar that sole and unreviewable is modifying discretion instead of a decision is also significant. And then additionally, the history that 1252 already barred the ultimate decision. So the Adam Walsh Act extended that to include the process as well.
What's your best authority from either our court or the Supreme Court that the distinction between whether the word is used as a noun or a verb changes the meaning in this fashion or in a significant fashion? Or where we or the Supreme Court have held that there's a significance for any purpose of statutory interpretation between the noun and the verb form of a word.
I don't know that I have a case that explicitly says noun versus verb, but in the cases that are cited throughout this case, they are dealing with cases where it is a verb. So, or sorry, that it is a noun. So in McNary, that it is a determination respecting an application, and then finding that that means final decision. So using a verb it means something different in this case. You know, and looking at the definition of determines, that it is including things such as consideration, investigation, calculation, that does refer to something that goes beyond the scope of just that one ultimate determination.
What's your response to the amicus's significant reliance on our decision and Make the Road? Because I noticed that the amicus in their briefing relied on that decision quite a bit, and I don't think you even cited it in your brief.
Yes, so in Make the Road is distinguishable for a couple of different reasons. So in that case, this court was dealing with a statute where the secretary was making a decision whether to subject an individual to expedited removal. And in that case, this court relied on a different statutory provision that explicitly provided for judicial review of that. So that was 1252 subsection E. And again, in that statutory language, which was such designation shall be in the sole and unreviewable discretion of the Attorney General. Again, such designation refers to an ultimate decision. Here we have, again, this is an affirmative decision about whether to extend a definition to put someone in expedited removal. This is an exercise of grace to allow an approval that otherwise Congress would have prohibited. There is no other statute that explicitly provides that this determination or that its underlying determination process should be reviewed. And the language that we're looking at, unless the secretary, in the secretary's sole and unreviewable discretion, determines that the citizen poses no risk, doesn't fall back onto the actual decision, but the determination-making process
So
itself.
when you emphasize such designation, is it the same noun-verb argument? If it
Yes,
said designates as opposed to designation, then
then it may have come out different.
Make the road would do the work.
Yes, that's possible.
If we disagree with your suggestion that Chayworth, or however you pronounce it, doesn't apply, we think it does, you lose.
Yes, but Chawith should not apply because, well,
No, if we disagree with that, you lose.
yes. But for Chawith, we have
Well, go ahead.
and we have an agency, deciding that this is going to be a binding precedent on the agency. An agency can't bind Congress and override what Congress has said in a statute. And here, the statute is saying that the discretion should be left to the secretary over the entire process. And the process would clearly include the burden to be applied in making that ultimate determination.
So then isn't the answer to Judge Edwards' question no then? Because I thought the premise of the question, but correct me if I'm wrong, is that whether Chayworth binds the agency, not whether it binds Congress. I mean, of course, an agency can't bind Congress, but if in fact it does bind the agency in this case, so that if the agency were faithfully applying the precedent, they would have applied a preponderance standard.
My apologies if I understood. So I don't think it's not possible for Chawith to override the statute. So it can bind the agency and say that where there is no burden of proof provided, then it's possible. But since we have the statute that says that the process should be left to the secretary's discretion, then it falls outside of Chawith.
In other words, the secretary, even though the secretary, per the secretary's own departmental expectations and regulations, is bound to follow the decision, if the secretary arbitrarily decides not to, then the statute would still immunize the secretary's determination from judicial review.
Yes, because Congress has said that this is within the secretary's discretion and that is going to be outside of the
Because you
ability
have,
for the courts to
as
review.
I understand, you have two arguments about the precedent. One is that the precedent doesn't apply because it doesn't cover this context. It covers different contexts. It applies a preponderance standard to a certain category of cases that doesn't encompass this one.
Yes.
And the other is that even if it did encompass this one, that still doesn't matter. We still don't have jurisdiction. And I think I thought that's what Judge Edwards was getting to, was the second point, that if we're on the part of your argument that says if Chayworth actually does apply here, then we still wouldn't have jurisdiction under the government's view.
Yes.
That's your.
So part of your argument then seems to be that the government has the authority to promulgate or adopt Chayworth and then apply it inconsistently as they see fit. And if they apply it this way, their response would be, well, the statute compelled. They apply it the other way, they'll say, well, we had the authority to issue Chayworth and we're bound to follow our own authorities. How can you have it both ways?
I don't think it's inconsistent to say if there is no burden supplied in the text, then it needs to be a preponderance. But of course, Congress can say otherwise. So if it's not inconsistent for
But they
an
adopted
agency to.
Chayworth with the statute in place. They have the authority to do that?
Yes, I believe
Issue
they could.
Chayworth with the statute in place.
Yes, because I
And the
think,
assumption I would have thought was that Chayworth will be controlling on this question. Because we have the authority to do this and we're doing it and it should be controlling. And the general rule is, unless the statute says something other than what it says, we can do this. But then the logical extension of that is they can do whatever they want on any given day. Just flip-flopping depending upon what seems to work.
well, no, I mean, only if there's congressional authority that.
No, but I mean, that the congressional authority thing is there in the first place. The statute is there, it says what it says. But Chayworth came despite its existence.
I think because Chayworth doesn't cover these decisions, the no risk determination under the Adam Walsh Act. So perhaps the agency could bind itself regarding other decisions at
But
that.
J-Waith isn't written with that limitation. It's saying in this kind of a situation, it would be preponderance, right? A literal
Correct.
reading of J-Waith supports the other side's position, right? It can't not support the other side's position, unless I'm missing something.
No, I would agree with that. I just think that, again, J-Waith covers a different scenario than what we have here, where Congress has written in that sole and unreviewable discretion to the secretary.
And where in J-Waith does it hedge?
I don't think J-Waith does, but I don't think it has to, because it would
Well,
not.
then
have been
you're in a
able to reach.
flip-flop. That's what I'm not understanding. They're adopting J-Waith,
Mhm.
and they're not suggesting, well, this is only good in certain kinds of situations. Because it's not clear the statute goes so far as to give the agency authority to go into these procedural issues. And there's nothing in J-Waith that's limited. I don't know how you get there.
I don't know that J-Waith would need to address every situation. I mean, it wouldn't have had to address any other discretion, like, other jurisdictional bars and things like that, like 1252. It wouldn't, I don't think J-Waith needed to necessarily explicitly say it will not apply to the AWA no risk determinations, because with that statute.
Maybe I'm missing this, but I thought your argument, let's suppose J-Waith comes down and Castaneira is pending before the secretary at the same time.
Mhm.
And let's suppose J-Waith just says, this, a preponderance of the evidence standard shall govern, including in the pending case of Castaneira. Okay, and then J-Waith issues, and then Castaneira comes down, and the secretary applies a beyond a reasonable doubt standard. Then is that reviewable? And the challenger says, wait a minute, J-Waith says preponderance. It even went so far as to say that it governs in this case, yet the secretary still applied a beyond a reasonable doubt standard and denied relief. We ought to get judicial review of that, and you, the court, should send that back. What would the government's position be?
I still don't think it's reviewable, because when you go back to the text of the Adam Walsh Act, it says that it's in the secretary's discretion to decide what the burden will be. So regardless of what the agency says will be in other contexts, I suppose if the secretary decided we are going to apply a preponderance standard and then proceeded to, in this individual case, and then proceeded to apply another one, I mean, that's still in the secretary's
Even that,
discretion.
why would that be different? I mean, from the government's perspective, I don't understand. I mean, your position has to be, I think, that even if the secretary violates the secretary's own admonition about the standard, as between beyond a reasonable doubt and preponderance, that it's still unreviewable. There's no legal error there that can be subject to judicial review, because the determination at the end of the day is that relief on this no risk calculus is going to be denied. That's off limits. And the burden of proof that's used to arrive at that is also off limits. And it doesn't matter how erroneous the selection of the burden of proof is. It doesn't matter if it flies in the face of a precedent. It doesn't matter if it flies in the face of the burden that's set out in the very decision itself. It's still off limits. It can't be touched by a court reviewing it. I thought, is that not how the government reads the statute?
Yes, it is. And I believe that that's how other courts that have addressed the issue have read it as well. In the Eighth Circuit in Bremer, the court noted that if courts begin to review USCIS's standards of proof and their adjudication procedures, that could easily dictate how USCIS is going to exercise its discretion with the ultimate determination. And that is exactly what Congress sought to prohibit with 1252 and the Adam Walsh Act.
So even if we thought that J-Waith did govern this case, then the government's position would be that we lack jurisdiction to correct that error.
Yes.
My colleagues have additional questions.
No.
Thank you, counsel.
Thank you.
Each will give you 2 minutes for a rebuttal.
Thank you, Your Honors. I want to pick up where we left off. I think Judge Edwards picked up on the government's heads I win, tails you lose type of argument with Chuaith, that even if Chuaith applies and the agency is violating its own binding precedent, that this court does not have jurisdiction to just narrowly correct that error. The statute doesn't give agencies carte blanche to ignore their own binding decisions. The Secretary chose to elevate Chuaith to binding precedent. He made that decision. These are the consequences. The Secretary gave this court a law to apply. This court can apply it and narrowly review the standard of review issue to bring the agency's actions in line with what is required by Chuaith. The
Secretary can change his mind or her mind, right?
That's right, Your Honor. We'd ask this court or ask the district court to instruct the Secretary to either go through the proper procedures to overrule the binding opinion in Chuaith or apply the preponderance standard because Chuaith clearly applies to administrative immigration benefits like the Form I-130 process here. The last point I'd like to leave you with, Your Honors, I think it's telling that the government doesn't have an answer to your question, Judge Wilkins, about the noun-verb distinction, because their position really boils down to this. You have jurisdiction over one form of the word. You do not have jurisdiction over the other form of the word. I just don't think that's enough considering the strong presumption in favor of reviewability of administrative action. Now, I don't want to say this case is cut and dry, but absent clear and convincing evidence that Congress meant to provide review preclusion over this particular type of challenge, this court has jurisdiction to review the agency's actions, and you should resolve your doubts in favor of reviewability. For those reasons, Your Honor, we respectfully ask this court to reverse. Thank you.
Thank you. Thank you to everyone who presented argument this morning. Ms. Beach, you and your clinic were appointed by the court to present arguments supporting the appellant in this matter, and the court thanks you for your assistance.
The Honorable Court now stands adjourned until Friday, March 21st at 9:30 a.m.